The regulations I read a few minutes ago out of your handbook state that a reservation wild rights committee manages the resource in the Mille Lacs area. Can you folks at DNR tell me if the DNR commissioner appoints committee members? And if not, how are they appointed? What term do they serve? When are their meetings? And are they open to the public? Which of you gentlemen can answer the questions?
I don't have the answer to those questions.
You don't know who appoints the committee?
I'm not familiar with that. Dave, do you have some?
I don't, I'm not on a committee of that purpose. I know that there is a wild rights committee within the department, within our section of wildlife. And I know that there's interaction between tribes and bands related to wild rice harvest. And at this point, that's the only information I would have about that, Mr. Courteau.
You don't know how the appointments are made to the committee, what authority appoints these members, and when they meet, nobody knows.
I'm not, at this point in time, I don't. I can certainly ask those questions. I'm not familiar with the answer to that.
Okay. Well, let's move on to this summary that I passed out to my colleagues. It states in number 4 that the band may establish the open season for harvesting wild rice within the 4 townships that comprise the original boundaries of the reservation. This season framework is binding upon non-Indians who reside in the area. My question to you folks at DNR is by what authority has DNR concluded in its summary that non-Indians who reside in the area are subject to any law or regulation that is or was not made by their elected representatives? Can you answer that question?
Well, I believe we came to discuss, the proposal for the restoration on Lake Ogeechee, and so I don't believe I have an answer for that specific question.
Okay.
And so we see it as a project proposal with some technical aspects that will provide that restoration of wild rice and waterfowl habitat. And that's the information I was prepared to bring to you.
Okay. Perhaps you could get back to me with a better answer to my question. I would be grateful.
We'd be pleased to.
I do have a couple of more. Your published regulations refer to an existing, that's the word that's used in your handbook, an existing Mille Lacs reservation. Why, since the controlling statute with respect to the harvesting of wild rice in this county refers to the reservation as the original boundaries, doesn't use the word existing. Why is there a difference between what you've published here and what is in the statute?
Commissioner Courteau, I don't know the answer to that question. And once again, I would refer back to that we were here to present some of the technical aspects of this restoration project. And we can certainly get answers for that question as well for you.
Would appreciate it, sir. Thank you. And I guess the last one I have is your regulations in your handbook clearly discriminate between non-native Minnesota citizens who do not possess any treaty rights. And I think everybody on this board understands that there are Minnesota and county residents who do have treaty rights, and they must be respected. but your regulations are discriminating between non-native citizens of this state and of this county, and including my own constituents. It appears that the DNR has carved out a special class of citizenry that for special privileges that fellow Minnesota citizens may not enjoy. Frank Courteau can harvest wild rice from Lake Onamia or possibly Lake Ogeechee, but Commissioner Peterson, Commissioner Edmonds, Commissioner Tellinghausen, and his brother cannot. My question is, what efforts is DNR making with the legislature to correct what is clearly unconstitutional? I don't believe the state of Minnesota can discriminate between Minnesota citizens with respect to its regulations that are managed by you folks. And so my question is, what effort is DNR making to correct what is clearly unconstitutional?
Commissioner Courteau, I'm Harlan Heenson, Public Affairs Officer for the Minnesota DNR Central Region. Commissioner Courteau and I have had some correspondence on this issue in the past. The restriction on wild rice harvesting to people within the original boundaries of the Mille Lacs Reservation goes back to a statute that was passed by the legislature and signed by the governor in 1937 or 39, I forget, one of those 2 years. Clearly, Commissioner Courteau, you believe that this law is unconstitutional. You're the only person I've heard that from. I'm not a constitutional law scholar or an attorney. I haven't heard that from anybody else. I think we know that within this nation, where the DNR to pick and choose, or where any individual to pick and choose which law it thinks is a good law and which law is a bad law, we have a prescription for anarchy. So short of someone at the level of the courts or the Attorney General's office informing us at the DNR, this law is indeed unconstitutional, as you suggest, I think it's our obligation as a state agency to follow the law as it is written. And again, as per our previous correspondence, there's a couple things that can be done to look at this law, this 1939 law. One is to work with the legislature to see if the law should be changed. And the other is to obviously.
That's my question.
I'm not aware of any efforts. I'm not aware that this has been identified within the agency.
Do you think the regulation is constitutional?
I'm not making any comment.
That you can discriminate between me and my colleagues with respect to who can wild rice in this county?
I'm certainly.
You're not offering an opinion. I'm assuming you don't take an oath of office.
I'm not offering a legal opinion on anything. I'm saying that you're the only person I've heard step forward to say that this law is unconstitutional. I'm not an attorney, nor a constitutional law scholar.
What would you think the reaction in this state would be, sir, if the DNR published a regulation saying that only the original residents of the Mille Lacs Reservation could fish on Lake Mille Lacs? Do you think that would be constitutional?
I wouldn't want to engage with that.
You wouldn't want to entertain? I think that's a cop-out, sir, but I appreciate your answer. With respect to my last question, you may think I'm the only person that thinks what you currently have in place is unconstitutional, but I would suggest that if you talk to most attorneys, that they are willing to give you a candid opinion, and especially if they're sworn under oath to treat everyone equally under the law, i.e. the 14th Amendment, they'll conclude that what you have in place is unconstitutional. And we're bound by oath to preserve and protect that Constitution. And if we see something that's unconstitutional, to point out to you that you have a problem. You're discriminating between my constituents and the citizens of this county and the citizens of the state of Minnesota with respect to your current regulations. You've got a problem. I think you should put a plan in place to correct it.